All right. Case number 24 CR 74, State of Ohio versus Deborah Hatfield. This is a Zoom hearing. Ms. Hatfield is appearing from the jail. Her attorney is William Armentrout, appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. The defendant is charged with 3 counts of aggravated trafficking and methamphetamine, 3 counts of aggravated possession, 5 third-degree felonies, 1 fifth-degree felony. This is the first pretrial, final pretrial set on the 20th November and December 9 trial date. I see that the state provided discovery and bill of particulars. Mr. Armentrout, you received those?
I have those, Your Honor. My client has copies of them. We have the offer, and my client has agreed to accept it, so I think I just need to get with your assignment commissioner, pick a date.
All right. Well, just go ahead and do that then. Anything else we need to discuss on this case? All right. Thank you. All right. Melissa Jenkins. All right, are you Alyssa Ray Jenkins?
Yes, Your Honor.
All right, this is case number 24 CR 78, State of Ohio versus Alyssa Ray Jenkins. This is a video or a hearing being conducted by Zoom. Ms. Jenkins is appearing from the jail. Her attorney is Dennis Kirk, appearing from his office. Appearing from the prosecutor's office is Prosecuting Attorney Collins. The defendant is charged with 3 counts of aggravated trafficking and methamphetamine, 3 counts of aggravated possession. There's a 2nd-degree felony and then 5 third-degree felonies. This is a pretrial scheduled by video. Ms. Jenkins says there's a plea of guilty form here that I have. So, Mr. Kirk, are you and your client both in agreement that this matter can proceed by Zoom rather than by an in-person hearing?
Yes, Your Honor.
All right. Now, is that all right with you, Ms. Jenkins?
Yes, Your Honor.
All right. If at any time during this hearing you need to talk to your attorney, just let me know, and I can put you and he into a breakout room and just be the 2 of you there for the hearing. No one else will be able to see you or hear you, and the deputy will step out. Now, I'm going to hold up to the camera there the plea agreement that says you're going to withdraw your not guilty plea and plead guilty to those 2 charges there. Do you recognize that?
Yes.
All right. It's counts 1 and 3, by the way. And page 3, there's a signature line halfway down the page. Right above that is I enter this plea voluntarily. It appears to be a signature of Alyssa Jenkins. Is that your signature there? Is that your signature?
Yes, Your Honor.
And when did you sign this document?
I think it was yesterday.
When you signed it, did you understand it was agreement to plead guilty, which means there's not going to be a trial in the next step? In your case,
Yes,
to be a
sir.
sentencing?
Yes.
And did you go over this with your attorney and have him explain everything to you before you signed it?
Yes.
And do you feel you had enough time to fully consider the matter before making this decision?
Yes, Your Honor.
And is this something that you did voluntarily?
Yes, Your Honor.
Are you going forward voluntarily now?
Yes, Your Honor.
Now, the agreement states you're going to plead guilty to counts 1 and 3, both aggravated trafficking and methamphetamine under 2925.03A1, the Ohio Revised Code, 3rd-degree felonies. Further states you understand that the penalty for each of those offenses could be between 9 and 36 months imprisonment, fine of $10,000, mandatory fine of $5,000, possible license suspension of 6 months to 5 years. If prison terms were imposed consecutively, it could be 72 months in prison as a maximum, $20,000 maximum fine, $10,000 mandatory fine. Do you understand that?
Yes, Your Honor.
Now, are you facing any felony charges anywhere else?
No.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, Your Honor.
Under the law, if you're convicted of this offense and sentenced to prison, once you complete that prison term, it is possible the Adult Parole Authority may put you under post-release control supervision for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised on the terms they set by a parole officer. If during that period of time they decide that you have failed to comply, they can return you to prison and make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. However, if your violation is a new felony, then in addition, whatever sentence a judge in a new case can impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. Do you understand that?
Yes, Your Honor.
Now, under the law, I'm not required to sentence you to prison. There's a presumption in favor of prison, but it's not mandatory. So I could put you under what's called community control for a period of up to 5 years, meaning you'd be supervised by a probation officer on a term set by the court. If during that period of time the probation department thought you were not complying, they would file a written notice of that with the court. You would get a copy. There would be a hearing at which you'd be entitled to have an attorney. If the outcome of that hearing was you failed to comply, then at that time the court could revoke your community control, then sentence you to prison for 9 to 72 months and fine you $20,000. Do you understand that?
Yes, sir.
Also, if you were convicted or revoked because of a conviction while under community control, then any sentence imposed for the new felony case could be ordered to be served consecutively to the sentence in this case. You understand that?
Yes, Your Honor.
All right, now the allegation of count 1 alleges that on or about February 7, 2024 in this county through February 8, 2024 in this county, you and a Donald Ray Allen Jr. did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount of less than 5 times bulk amount in violation of Section 2925.03A1, charge of aggravated trafficking of methamphetamine, a third-degree felony. Now, count 3 is the same charge and reads the same, except it alleges that it happened on or about February 10, 2024. Otherwise, it's the same offense with the same penalty. Now, do you understand what it is you've been charged with, and as counts what the state said you did, when, where, and how they alleged you did it?
Yes.
Have you discussed the nature of the charges, the evidence in the case, possible legal issues in the case, the possible defense you might try to raise at trial, possible outcomes of a trial with your attorney?
Yes, Your Honor.
Are you satisfied with his advice and competence in this matter?
Yes.
Are you under the influence of any types of drugs or alcohol at this time?
Oh, no, Your Honor.
Have any threats been made to make you plead guilty here today? All right, now, page 2, there are several lines that are printed in bold and underlined and read as follows. Defendant will enter a plea of guilty to count 1 and count 3. State will dismiss remaining counts. State and defense jointly recommend 18 months incarceration on count 1, consecutive 18 months incarceration on count 3. State will not oppose judicial release to substance abuse treatment after 6 months incarceration. Defendant agrees to cooperate fully with the task force. Defendant agrees to repay by money to the task force the amount of $600. That's your understanding of the agreement?
Yes, yes, sir.
Does anyone promise you anything other than that to get you to plead guilty?
No, sir.
Under the law, Ms. Jenkins, the matter of sentencing as well as judicial release is up to the judge, not the parties. And so even though there's an agreement you should receive a sentence of 18 months, I'm not required to follow that recommendation. That is on each count, so a total of 36 months. You could get as much as 72 months or as little as 9 months. And in the event that you are sentenced to prison, the court's not required to grant you judicial release simply because the state's not opposing it. The court will still have to determine whether or not to grant that. You understand?
Yes, sir.
All right. Now, do you hold any license or certification from any state governmental agency that regulates any occupational profession in Ohio?
No, Your Honor.
You have certain constitutional rights you must understand before I can accept a plea from you. First of all, you have a right to have an attorney, and I appointed Mr. Kirk to represent you. That appointment wasn't simply to work the case out, but to provide any defense that may be available to you under the law that you'd like him to provide. So if you decide you don't want to do this, that you want to defend against a charge, he will continue to represent you and defend you, including a trial if that's what you want. Do you understand that?
Yes, Your Honor.
All right, now, under the Constitution, you have a right to have a jury trial in this matter in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After 12 of those folks are selected, the evidence would be presented, they'd be instructed on the law, and then that jury of 12 would decide by unanimous verdict, meaning all 12 would have to agree, whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive, which means to give up in writing your right to have a jury trial, In that case, you would have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, it would be the judge would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, Ms. Jenkins, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is the witnesses against you have to come into court, testify in front of you and your attorney and anyone else may be present. After the prosecutor's done asking questions, your attorney can ask questions. That's called cross-examination. The purpose of that is to try to bring out evidence that might help your side of the case. Do you understand that?
Yes, Your Honor.
Now, in the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're uncertain going to come in voluntarily, your request, the court issues a court order, is called a subpoena, and that forces those witnesses to come to court to be able to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, Your Honor.
Under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to talk about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is that the burden of proof is on you to try to prove that you're not guilty simply because you've been accused. In fact, under the law, you don't have to put on any defense at all. You may, but you're not required to. But whether you do or not, the burden will remain upon the state of Ohio to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
Originally, Mr. Jenkins, you entered a plea of not guilty, which denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all the rights I've just described. Now, if you change your plea from not guilty to guilty, that is the opposite of the not guilty plea. Plea of guilty to counts 1 and 3 would admit the allegations in those counts, admit that they're a crime, that you committed that crime, and that plea would waive or give up all the rights that I've just explained for you, except your right to have an attorney, which you always have no matter what your plea. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial, would waive or give up your right to confront witnesses against you, cross-examine them through your attorney, would waive or give up your right to compel witnesses to come to court to testify on your behalf, the same as the state. It would waive or give up your presumption or your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It would waive or give up your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. Finally, it waives or gives up any right to file an appeal you think you may have had up to this point in the case. Now, if I should sentence you the maximum sentence or under the limited circumstances you can file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes, Your Honor.
Now, do you have any questions about the charges or the possible penalties?
No, sir, I don't, but I would just rather just plead guilty now and go in my time, get it over with.
All right. So you do understand the charges and the penalties?
Yes, Your Honor.
Okay.
I do.
You have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes.
You have any questions about the plea agreement that I've gone over with you?
No, Your Honor.
You understand it?
I understand fully.
And you understand that the recommendation on sentencing is not binding on the court, nor is the fact that the state's not opposing judicial release, meaning you're going to get judicial release if I do send you to prison. You understand that?
Yes.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No.
All right, is there anything you need to speak to your attorney about before we go any further?
No, I don't. Thank you.
Then is it your decision to go forward and plead guilty to counts 1 and 3 pursuant to the agreement we just gone over?
Yes, Your Honor. It's
And
mine.
as to the charge in count 1, which alleges that on or about February 7, 2024, continuing through February 8, 2024 in High County, Ohio, that you and Donald Ray Allen Jr. did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance amount equal to or exceeding bulk amount less than 5 times bulk amount, violation of Section 2925.03A1 of the Ohio Revised Code, the charge of aggravated trafficking methamphetamine, third-degree felony, current possible prison term between 9 and 36 months, fine of $10,000, mandatory fine of $5,000, possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
And as to count 3, which alleges the same offense except that it's alleged to have occurred on or about February 10, 2024, otherwise the same offense, same penalties. How do you plead?
Guilty.
All right, thank you. The court finds in this day in open court, the defendant was advised of all of her constitutional rights, made a knowing, intelligent, and voluntary waiver of the same pursuant to Criminal 11. Pleas are accepted, order filed. Defendant is found guilty of counts 1 and 3 as charged. Counts 2 and 4 through 6 are dismissed. As much as there's a joint recommendation on the penalty and the nature of the offenses, the court will proceed with sentencing forthwith. Anything from the state?
Only what's contained within the plea agreement, Your Honor.
Mr. Kirk?
Thank you, Your Honor. Would ask the court to follow the plea agreement. In this case, my client has no prior criminal record. She got mixed up with her co-defendant, Mr. Allen, and that led to these charges. She has been very cooperative with me, and I think long-term is very open to treatment, and I think the hope would be, and I've explained to her, judicial's not guaranteed by any stretch, but if she can get that, I think she'll take the treatment seriously. Thank you.
All right, Mr. Jenkins, anything you'd like to say?
No, just that what my attorney said, I would take it serious, but other than that, no, sir.
All right, well, it's your the court that you be and are hereby sentenced on count 1 to a term of 18 months at the Ohio State Reformatory for Women at Marysville, Ohio, and to the same amount of 18 months on count 3, also in the same facility. Those sentences are ordered to run consecutively to one another for a total of 36 months. Consecutive sentences being appropriate since it is a joint recommendation. The offense was committed as part of a series of one or more courses of conduct, and the harm was such that one single prison term will not adequately reflect the seriousness of the offenses, nor is the sentences being imposed disproportionate to the harm caused. Now, you'd be given credit on that of, looks like you're arrested on September 14th, is that correct?
Yes, Your Honor.
All right. Today is the 16th, so there'll be 32 days of jail time credit. Now, upon completion of this prison term, if you serve the entire term, the Adult Parole Authority may put you under post-release control supervision for a period of up to 2 years. If they do, you'll be supervised on the terms they set by a parole officer, and if they determine you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months for single violation, up to a maximum of 1/2 of the prison term for all violations. But if you commit a new felony while under post-release control, then in addition, whatever sentence the judge in a new case could impose upon you, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively to the sentence in the new case. You're also ordered to pay the court costs, which judgment, grant, and execution is ordered. If you fail to do that, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of that sentence, not while you're in prison, but once you get out, the court could permit you to do community service in this county and give you credit for each hour you work in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. You're also ordered to make restitution in the amount of $600 to the Hynekee County Drug Task Force, payable through the Hynekee County Victim Witness Restitution Escrow Account, to pay any service fees charged for that. Has there been any financial change in your financial circumstances since I appointed Mr. Kirk to represent you at your arraignment?
No.
All right, then the court will find that the defendant does not have the ability to pay the mandatory fine, nor is she likely to have it in the near future, and therefore that will be waived. All right, is there anything further from counsel?
No, Your Honor.
All right.
Hey, Your Honor.
All right. Let's do Justin Alexander next, please. All right, this is case number 24CR124, State of Ohio versus Justin Anthony Stubbs. Are you Justin Anthony Stubbs appearing there from the jail?
Yes, sir.
All right, this is a pretrial on an indictment. He was charged, Mr. Stubbs was charged with receiving and aggravated possession of methamphetamine. His attorney is appearing from his office by Zoom, Mr. Kirk. Appearing from the prosecutor's office is prosecuting attorney Collins. And Ms. Collins, has the alleged victim in count one been notified of the time, place, and purpose of this hearing, the right to be heard?
Their representative was notified of the hearing. They'll not be here, and
All right.
they were notified of their right to be heard if they wanted to be here.
All right. Now, this is a first pretrial, or final pretrial, trial set for November 12th. I see discovery is provided by the defense, so discovery complete from both sides.
Perhaps, Your Honor. We got the defense's discovery on October the 11th. However, there was a written statement that was also sent. We just received that today, and we need to track down what's alleged in the written statement. So following that, there may be additional discovery.
All right. There are no pretrial motions this time?
Not at this time.
All right. And has there been a written plea offer provided?
There has.
Your client's aware?
He is aware of it, yes.
All right. So what's the situation? Has he signed a rejection of that plea form?
He has not yet. I know we've got the 2-week rule, and I've explained that to him. Based on what I provided the state, I think they want to talk to somebody additional that may have an impact.
All right. All right. Anything else, Ed?
Hey, Your Honor.
All right. Then.
If we end up with a plea or anything, we'll call it or request a hearing.
All right. That'll be fine. All right. Thank you.
Mr. Collins, can I speak for a minute?
What's that?
Can I ask you a question? Are you done with your proceeding?
I'm done at this point, Chef. You want to?
Okay, I have a question for you if I'm allowed.
What is it?
I was just wondering, I don't understand something about this case where
Well,
all
now,
this.
if it's something about the case, you're going to have to talk to your attorney. I can't explain it to you because I probably don't know as much as you do. I'm just presiding over the case. I haven't read the file. I don't know who the witnesses are or anything of the
It
nature.
all happened in Ross County.
Well, I don't know anything about that.
that.
So you will have to talk to your attorney, and your attorney sounds like they're giving you some information or information that they're investigating, but you need to talk with him. I can't answer questions like that because I don't know. I'm the judge.
Mr.
I'm
Curry,
not
you going to be able to come back out today to
Pardon me?
just to speak with me? Is he
It
going
won't.
to out and speak with me today?
It won't be today, but I will be back out in the next couple of days.
All right, thank you.
Okay. All right. Thank you. Robbie Munyon would be next. All right, this is case number 24CR130, State of Ohio versus Robbie L. Munyon. You're Robbie L. Munyon appearing there from the jail?
Yes, sir.
All right, this is a pretrial on an indictment returned by the grand jury charging Mr. Munyon with aggravated trafficking, aggravated possession, and methamphetamine third-degree felonies. His attorney is Dennis Kirk, appearing by Zoom from his office, appearing by Zoom from the prosecutor's office, Prosecutor Collins. It's the first pretrial. The defendant's final pretrial is November the 8th, and trial is December 19th. See, the state provided the bill particulars and discovery. You received that, Mr. Kirk.
I have, Your Honor.
All right. Your discovery then will be due by the final pretrial. Do you anticipate any pretrial motions at this point?
Not at this point.
All right. Well, if you do decide there are any, they're due by the final pretrial. Has there been a written plea offer received?
There has, and I have relayed that to my client.
Okay. All right. Are there any other matters need to be discussed then at this time?
Not from the state.
No, Your Honor.
All right. Thank you. All right. Let's see. Mr. Stewart's not in jail?
No.
All right. Matthew Seagraves would be All right, this is State of Ohio versus Matthew R. Seagraves, 24 CR 118. Are you Matthew Seagraves appearing there from the jail?
Yes, sir.
All right, this is a hearing being conducted by Zoom on a pretrial and also a motion to revoke bond. Defendant's attorney is Catherine Hapner, appearing from her office, appearing from the prosecutor's office, prosecuting attorney Collins. Defendant's charged with 2 counts of assault on a peace officer. Ms. Collins, has the alleged victim or victims of these offenses been notified of the time, place, and purpose of this hearing, the right to be heard?
They have, Your Honor, and they'll not be here.
All right. We'll do the pretrial first. See that state provided discovery. Well, by the way, this is the first pretrial. This trial is set for December 9th. Final pretrial is November 6th. All right, so the state provided discovery on the 3rd and a bill of particulars on the 4th. You received both of those, Ms. Hapner? You're muted.
Talking to me?
You're still muted, Ms. Hapner. You might want to check. Okay, you want to log out and log back in, and then maybe that'll fix it. Might want to check the settings on your computer. Could it be it's turned off or muted on your computer?
Oh, okay, did that?
Oh, there you are.
Am I on there? Okay.
Okay. All right. So, Ms. Hapner, you did receive the discovery of the bill of particulars?
I did, yes.
All right, and your discovery is due by the final pretrial. At this time, do you anticipate any pretrial motions?
I do not.
All right. Has there been a written plea offer received yet?
There has been, I have not yet given that to my client.
All right. Are there any other matters to discuss other than the motion to revoke bond then?
No, I think it's just that bond motion.
All right. Ms. Collins, then I'll let you speak to the motion to revoke bond.
Thank you, Your Honor. As noted in my motion to revoke his bond, Mr. Seagraves was involved in a domestic violence incident, was charged with domestic violence in the Hillsborough Municipal Court, and is ordered by the Hillsborough Municipal Court to have no contact with the victim. He was arrested on this charge on October 6th of 24. He's been ordered to have no contact with the victim. Well, the victim, or the alleged victim, is the owner of the house where he was living pursuant to the court's order of house arrest. So currently he has no known residence that he is going to, because he cannot have contact with the person whose house he was staying at pursuant to this court's order.
All right. Anything further?
Not from the state.
Ms. Hapner, anything you'd like to say?
Thank you, Your Honor. I do believe that the municipal court has a stay-away order against Mr. Seagraves for the victim in the alleged domestic violence case, which, as Mrs. Collins stated, is the address he had listed for this court. I would ask that if he is able to provide me with another address and we are able to verify that he is welcome there, that the court would revisit the motion at that time.
Well, what's the situation with the bond in municipal court? I see he's in custody. He's in custody on the municipal court case, correct?
Correct.
I believe the problem is that he has been ordered to have EMHA, and he can't provide an address for that EMHA hookup yet.
Okay. All right. Well, the court's not going to revoke the bond, but the court will modify the bond on the basis that you will have to have a different address
Yes, sir.
to live at. to be released.
And,
Don't interrupt me. And then all other conditions will continue. Now, and the reason I'm not revoking a bond is because there's been no violation of the bond in this case. It's not alleged that he's violated any other conditions of bond, or any conditions of bond, other than the fact he can't live there, and so the court's modified to say that he'll have to be at a different location other than that. And until that's demonstrated, he will not be released. All right. Anything further, counsel?
No, Your Honor.
All right, thank you. CR 210, State of Ohio versus Justin Alexander. This is a hearing being conducted by Zoom. Mr. Alexander is appearing from the probation department. His attorney is Catherine Hapner, appearing from her office. Appearing on behalf of the state is prosecuting attorney Collins. The defense charged with 1 count of aggravated possession of methamphetamine and is set for a jury trial on November the 12th. Today's the final pretrial. Been provided with a plea of guilty form. Ms. Hapner, are you and your client both in agreement this matter can be conducted by Zoom rather than in-person hearing in the courtroom?
Yes, we are.
And you're all right with that, Mr. Alexander?
Yes, sir.
All right, if you should need to talk to your attorney or ask her a question while we're in this hearing, since you're not in the courtroom, just tell me. I can put the two of you in a breakout room. It will be just the two of you on the screen talking to each other. No one else will be able to see you or hear you, okay?
Okay. Yes, sir.
All right, I'm going to hold up this agreement that has your name and case number, says plea of guilty on it. You recognize that document?
Yes, sir.
On page 3, there's a line that reads, I enter this plea voluntarily, and right below that there's a signature of defendant line. Is that your signature right there I'm looking at?
Yes, sir.
And when did you sign this document, Mr. Alexander?
Probably about quarter to 1.
Okay. And when you signed it, did you understand that it's an agreement to plead guilty, which means there won't be a trial? The next step in your case will be a sentencing hearing?
Yes, sir.
Did you have enough time to fully consider the matter before making this decision?
Yes, sir.
And did you enter into this agreement voluntarily?
Yes, sir.
Are you going forward today voluntarily?
Yes, sir.
Now, agreement states that you're going to plead guilty to the charge in the indictment of aggravated possession of methamphetamine under 2925.11, the Ohio Revised Code, a 5th-degree felony. Further states you understand the prison term for that could be between 6 and 12 months, could be a fine of $2,500, it could be a license suspension of 6 months to 5 years. You understand that?
Yes, sir.
Are you facing any felony charges anywhere else?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony?
No, sir.
Now, under the law, if you are convicted of this offense and should be sentenced to prison, upon completion of that, it's possible the Adult Parole Authority may put you under post-release control for up to 2 years, meaning you'd be supervised on terms they set by a parole officer, and if during that period of time they felt that you were not in compliance, they could return you to prison and make you serve an additional period of up to half of your prison term for one or more violations. However, if you commit a new felony, then in addition, whatever sentence a judge in that new case could impose upon you, that judge is also authorized to sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is remaining on that post-release control, whichever is greater. If that occurs, that must be served consecutively the sentence in the new case. Do you understand that?
Yes, sir.
Under the law, I'm not required to sentence you to prison for this offense. I can impose what's called a non-prison or community control sanction, which most people know to be probation. And that means that instead of going to prison, you'd be put under the supervision of a probation officer, a term set by the court for a period of up to 5 years. And if during that period of time probation felt that you were not complying, they would file a written notice of that with the court. There would be a hearing. You'd be entitled to have an attorney. The outcome of that hearing was that you had not complied. Then at that time, the court could revoke your commitment control and then sentence you to prison for 12 months and fine you $2,500. And if that occurred because of a new conviction, and you received a prison term for that, then that prison term could be served consecutively to the prison term in this case. Do you understand that?
Yes, sir.
Now, the charge alleges that on or about June 1, 2015, Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, in violation of Section 2925.11 of the Ohio Revised Code. So that's the charge of aggravated possession of fifth-degree felony with the penalties I just described. Now, do you understand what it is you're charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
Have you discussed the charge, the evidence in the case, possible legal issues in the case, possible defense you might try to raise at trial, and possible outcomes of a trial with your attorney?
Yes, sir.
And are you satisfied with her advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to make you plead guilty here today?
No, sir.
Now, on page 2, there's a couple of lines printed in bold and underlined that read as follows. Defendant shall enter a plea of guilty to the indictment. State and defense jointly recommend community control and admission to the drug court docket. Is there anything other than that that's been promised to you?
No, sir.
Under the law, the matter is sentenced up to the judge. And so even though there's a recommendation of what that sentence ought to be, of being community control of drug court, neither of those recommendations are binding on the court. You understand that?
Yes, sir.
Do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
No, sir.
All right, now you have certain constitutional rights you must understand before I can accept a plea from you. First of all, you do have a right to counsel, and I appointed Ms. Hampton to represent you. That wasn't simply to work the case out, but to provide whatever defense may be available to you under the law that you're likely to provide. So if you decide you don't want to do this, that you want to defend against the charge, she'll continue to represent you, including at trial, if that's what you want. Do you understand that?
Yes, sir.
Now, under the law, you have a right to have a jury trial in this matter, Mr. Alexander, which means that a jury of 12 people would be chosen from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After those 12 are selected, the evidence will be presented. They'd then be instructed on the law, and then that jury of 12 would decide by unanimous verdict whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive in writing, which means you give up your right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning instead of the jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else that may be present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that may help your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, your request for court will issue a court order is called a subpoena. And that will force those witnesses to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter or to testify at any time, including the trial. No one can ever make you testify. The prosecutor can, the judge can. It's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in the proceedings. And in fact, no one can even talk about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
All right, now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charge. What that means is that the burden of proof isn't upon you to try to show you're not guilty simply because you've been accused of this offense. In fact, under the law, you're not required to present any evidence at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond a reasonable doubt on every element of the offense charge, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Originally, you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and then exercised or revoked all the rights I just described. Now, if you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea will admit the allegation in the indictment and admits that there are a crime, that you committed that crime. And that plea will waive or give up all of the rights that I've just described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But without exception, your plea of guilty would waive or give up your right to a jury or a court trial. It would waive or give up your right to confront witnesses against you, cross-examine them through your attorney. It would waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It would waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what you find you guilty. It will waive or give up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence, or under other certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. You understand all that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
All right, now, do you have any questions about the charge or the possible penalty?
No, sir.
You understand it?
Yes, sir.
You have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
You have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
Yes, sir.
All right, do you have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, sir.
You understand?
Yes, sir.
Is there anything you need to speak to your attorney about before we go any further?
No, sir.
All right, then is it your decision to withdraw your not guilty plea, plead guilty to the charge pursuant to the terms of the agreement we've just gone over? Is that your decision to plead guilty?
Oh, yeah. Sorry. Yes, sir.
Not a problem. All right, and you're doing that voluntarily?
Yes, sir.
Then as to the charge which alleges on or about June 1, 2015, Highland County, Ohio, you did knowingly obtain, possess, or use Schedule 2 controlled substance with methamphetamine, a violation of Section 2925.11 Ohio Revised Code, a fifth-degree felony, carried a possible prison term of between 6 and 12 months, fine of $2,500, and license suspension for 6 months to 5 years. How do you plead?
Guilty.
All right, the court finds on this day in open court, defendants advised of all of his constitutional rights, made no intelligent voluntary waiver of the same pursuant to criminal 11. Please accept the court filed. Defendants found guilty of the charge as alleged in the indictment. Court will refer the matter to the probation department for a pre-sentence report and also refer it to the drug court docket. Sentencing would be November, are you available November 18, Ms. Hafner?
No, that's my regular day in Fayette County.
Right. How about Wednesday the 20th?
I'm available in the afternoon, but not the morning.
How about the 21st?
No, I'm not. Well, I could do it early in the morning. I got to be in municipal court at 9, and then I'm up in Fayette County in the afternoon, so I could do it before municipal court.
All right, about 8:30.
That'd be fine.
All right. All right. So it'll be November 21st at 8:30 a.m. And you'll need to be here in court, Mr. Alexander. All right.
Yes, sir.
So see the probation department on your way out for your appointment. All right?
Yes, sir.
All right.
Right there. Here. Luke's on over in front of the thing. Okay, you're off mute, so you're good.
All right. This is case number 24, CR 136, State of Ohio versus Kevin Stewart. You're Kevin Stewart, appearing there from the probation department.
Yes, Your Honor.
All right. This is a pretrial. Mr. Stewart was charged with 3 counts of trafficking, a fentanyl-related compound, 3 counts of possession, a fentanyl-related compound. His attorney is Dennis Kirk, appearing from his office. Appearing from the prosecutor's office, Prosecutor Collins. I believe this is a first pretrial. And let's see, final pretrial is set November 6th. Trial date is December 9. All right. See that the state's provided discovery. You received that, Mr. Kirk?
I have received it, yes.
All right. Your discovery will be due by the final pretrial. Do you anticipate any pretrial motions?
Not at this time.
And have you received a written plea offer?
I have.
All right. Is your client aware of it?
He is not yet aware of it.
All right. All right. Are there any other matters that need to be discussed then at this time?
Not from the state.
No, Your Honor.
All right. You need to get in touch with your attorney, Mr. Kirk, or Mr. Stewart, so you can set up an appointment to discuss the case with him, okay?
Okay.
All right. Thank you.
Thank you, Your Honor.
All right. All right, this is case number 24, CR 128, State of Ohio versus Christopher Ernest Holt. You're Christopher Ernest Holt, appearing there from probation.
Yes, sir.
All right, this is a pretrial being conducted by Zoom. Mr. Holt's attorney is Sarah Barger, appearing from her office. Appearing from the prosecutor's office, Prosecutor Collins. It's the first pretrial. Final pretrial set for November 6th. Trial date's December 9. Defendant charged 1 count of aggravated possession of methamphetamine. See, the state provided discovery. Ms. Barger, your discovery will be due by the final pretrial. And do you anticipate any pretrial motions?
Not at this time, Your Honor.
All right. Well, if you do have any, they'll be due by the final pretrial as well. Has there been a written plea offer provided?
There has been.
Sure.
Is your client aware of it?
He is not, Your Honor. I have not heard from my client.
All right. All right. You need to contact your attorney then, Mr. Holt, to discuss this matter. You want to give me your phone number, Ms. Barker?
Sure thing. Can you write it down?
I don't have a pen.
All right.
I got it, Miss Barber.
Thank
Okay.
you.
You've got it, Officer Benson. Okay. See Ms. Benson on the way out and get the phone number for your attorney and give her a call, all right?
Okay.
All right. Anything else to discuss?
No, Your Honor.
All right. We'll see you at the next pretrial then.
Thank you.
All right.
Let's see. You're already off on you. Yeah, you're good to go.
All right. This is case number 24 CR 129, State of Ohio versus Christopher Thomas Chaffin. You're Christopher Thomas Chaffin.
Yes, sir.
All right. Mr. Chaffin is appearing from the probation department by Zoom. His attorney is Sarah Barger, appearing from her office, appearing from the prosecutor's office, prosecuting attorney Collins. Been charged with 1 count of aggravated possession of methamphetamine. This is the first pretrial. Final pretrial is November 20. Trial date is December 19. See, the state has see, I thought I saw discovery. Yeah, here we go. Bill particulars and discovery was provided recently by the state on the 9th and 10th. You've received those, Ms. Barger?
I have, Your Honor.
All right, your discovery will be due by the final pretrial. And do you anticipate any pretrial motions?
Motion for intervention in lieu of conviction was filed this morning.
A what?
A motion for intervention in lieu of conviction was filed.
Okay. All right. Was were the stipulated questions included with that?
Not yet. I have a meeting next week with Mr. Chafin.
All right. All right. As soon as you get that, then we'll order that evaluation take place. Is Mr. Chafin in treatment of any sort now?
No.
All right. Well, that intervention requires you to be evaluated for substance abuse or mental health issues to determine if those are required treatment would have any bearing on whether or not you committed the offense. So you'll need to talk with them about getting that as soon as you meet with your attorney about getting that evaluation done right away.
All right.
All right. Thank you. All right. Is Dylan Downs there at the probation department? All right, this is case number 24 CR 126, State of Ohio versus Dylan Aaron Downs. And are you Dylan Aaron Downs appearing there from the probation department by Zoom?
Yes, sir.
All right, Mr. Downs' attorney is Danielle Witt, appearing from her office. Appearing from the prosecutor's office is prosecuting attorney Collins. The defendant is charged with 1 count of aggravated possession of methamphetamine, a 5th-degree felony. This is the first pretrial. Final pretrial set for November 6th. Trial date is December 9. See, the state did provide discovery and a bill of particulars. You received that, Ms. Witt?
I have, Your Honor.
All right, your discovery will be due by the final pretrial. And do you anticipate any pretrial motions?
No, none at this time.
And have you received a written plea offer?
I have.
Is your client aware of it?
He is not. I need a phone number for him or for him to come to my office right now.
All right, can you go right to her office as soon as you get done here?
Yes, I can.
You know where that's located here at North High Street?
No, sir.
All right, just north of the courthouse. What is it, the second door from the old firehouse?
Okay.
Yeah. And it has a sign out front. Okay. So as soon as you get off the air here, you go up there.
Okay.
All right. Thank you.
Thank you.
All right. And you have Mr. Kessinger there at the probation department? All right, this is case number 24 CR 113, State of Ohio versus Roger Allen Fillmore. You're Roger Allen Fillmore appearing there on the screen, marked Samsung SM5711U.
Yes, sir.
All right. This is a pretrial being conducted by Zoom. And Mr. Fillmore's attorney is Catherine Hapner, appearing from her office, appearing from the prosecutor's office, prosecuting attorney Collins. Defendant is charged with illegal conveyance, a 3rd-degree felony, and trafficking and possession of cocaine, both 5th-degree felonies. This is final pretrial. The trial date is set for November the 14th. I guess it looks like discovery was provided by the state back in September. I don't see your compliance, Ms. Hapner. Have you filed that yet?
I have not.
Okay, well, it's actually due to today. I'll give you until Friday.
Okay.
And no pretrial motions either?
I've not met with my client.
I'm sorry?
I've not met with my client, so I don't know. He had an appointment with me last week and did not keep it. So
My grandmother had a heart attack and was in the hospital.
Okay, well, that's a shame. I'm sorry to hear that, but you need to contact your attorney when that happens and let her know so that you can make another appointment because you got a trial date coming up on November the 14th. So you need to be paying attention to that. I know that your granddaughter is a concern, but your concern is also this case. So
Yes, sir.
you need to go ahead and contact her and make another appointment as soon as we get done here today. You call her office and make an appointment. All right. Any other matters?
Your Honor,
Go ahead.
can I inquire as to where Mr. Fillmore is living? We have another case with him.
I'm living in. Huh?
I don't know what he said.
My mom and dad's in Fruitdale, outside Greenfield.
In Fruitdale?
Yes, ma'am.
I don't know where that's, I mean, I know where Fruitdale is, but I don't know where he's living. He's supposed to be with
That's where I'm living, but I asked the judge the last time I was in court if I could be at my parents' house as well, because that's where kids live. The only people that I go, other than working.
His parents?
It's probably as part of his agree.
All right. Anything else then we need to discuss? I think what we'll leave it at is this, Mr. Fillmore, if you don't get with your attorney, then, you know, we have a trial coming up on the 14th of November, and if you don't want to talk to her, that's up to you. It means that she's not going to be able to do a very good job defending you, but that'll be your fault, not hers. And so, you know, if you want her to do a good job for you, you need to be talking to her right away. Understand?
Yes, sir.
All right.
Yes, sir.
Anything else from counsel?
No, Your Honor.
All right, thank you. Is that everybody then?